This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and thank you, Ms. Dyer and Mr. Pentecost, for agreeing to participate with Judge Stafford, Judge Armstrong, and I during this live streaming oral argument. Please understand that we will conduct the hearing today in the same manner as if we were all together in the courtroom. And each of you has 15 minutes, and the appellant has reserved some of that time for rebuttal, and Mr. Hibner has programmed the clock accordingly. Unless there are any announcements, I will ask Mr. Hibner to call the case. Mr. Hibner.
Ryan Kimble versus Dyer County, Tennessee et al.
Ms. Dyer, you have the floor.
Good morning, Your Honors. Thank you for allowing me to be here today to present my case to you. My name is Barbara Dyer. I'm a member of the Dyer County Bar. I've been practicing law in Dyer County, and I'm here today representing the interest of Ryan Kimble, the plaintiff in the case below. My case is a negligence action against the Dyer County, the Sheriff's Department with Sheriff Jeff Box, and an unknown deputy who committed the act. The case occurred during a tornado in early 2018, excuse me for that. Mr. Kimble was traveling upon the highway during the tornado. The accident occurred due to the fact that the deputy that was dispatched to the scene where the accident eventually occurred was dispatched by the county 911, and a deputy arrived and took control of the tree. There was a tree on the road that was the cause of this. We did not argue that the tree was the cause of the accident. We argued that the cause of the accident that injured Mr. Ryan was the fact that the deputy took control of the situation. He arrived, took control of the situation, and then left without any warning to anybody on the highway. And that particular anybody on the highway just happened to be Mr. Ryan Kimble, who was headed that way in a storm, unknown that there was any sort of danger in front of him. Mr. Kimble's accident was very traumatic to him, and it caused him a lot of pain, suffering, time in the hospital. We feel that the deputy caused the accident, and we're, I guess, arguing today that the defendants in this case are trying to use the governmental tort liability as their shield, saying that they cannot be sued for various reasons. One of those being TCA 2920-201 at SEC. If that is the defense, I've raised, or they've raised 203 and 205 sections in specific in this case. The first one would say that the Dyer County is not, or they are immune to the situation under the fact that the highway is a state highway controlled by the Highway Patrol Department.
Do you agree? Do you agree that it is a state-owned highway?
Yes, sir, it is. It has a sign out there.
All right.
Our position on this is that it was not a defective road. There was nothing other than there was an emergency situation, and in emergency situations, you don't have your normal who does what. But we haven't got that far in the case yet, so I don't want to go there. Anyway, the deputy took control of the situation. It was an emergency. He took control of the situation. And as far as the Highway Patrol being the people that should have been over this situation, the deputy was dispatched by the 911. That's in my complaint. and the deputy took control of the situation and left. He just left. He didn't put any kind of warning signs out there. He didn't try to remove the tree from the road. As far as we know, he got out there, saw the tree, and went to another situation where there was another call for another tree on the road. So in my position and Mr. Ryan Kimble's position is that this deputy took over and just left it and he intended to do that. He left intentionally to go to another tree over the road.
Miss Deere, if the deputy owed a duty and allegedly breached the duty, was it a duty that he owed specifically to your client or to any and all persons who might be traveling that road that night?
Well, Your Honor, it's our position that he owed that duty to Mr. Kimble, who was the person traveling toward that incident. And this is not, I think I know where you're coming from. You're talking about the public as a whole. There could only be one person who's going to hit that tree, and that person just happened to be Mr. Ryan Kimble. The public was not all on that highway headed toward that tree that night. Mr. Kimble was headed toward that tree, and we believe that the deputy owed a duty to that person that was coming toward that tree to get the tree off the road, because he assumed that duty by showing up out there as a law enforcement officer taking control of the situation. As far as the other code section for the governmental tort liability, we believe that the officer was performing his duty or was attempting to perform his duty. I don't think he did a very good job, but he showed up at the scene and he was in the scope of his work, and he left that job, and that was we consider that a negligent act by a governmental employee, which would remove immunity from the government at the stage of when he committed his negligence. If you can remove immunity from there, you would go to the public duty doctrine to see if they have a second layer of defense, which is a common law duty. It's not a statutory duty. That arises from common law a couple of centuries back, I believe, where they were trying to protect the police so that the police could do their duties. If you're trying to protect the police so the police can do their duties, then it's our position that the police or the deputy should do their duty. They should not be given free rein to pick and choose what to do when the duty calls. The public duty doctrine has 3 exceptions to it, and we fit into that third category of the special duty exception, which is where I believe you were going, Judge Clement, at their the public duty. Mr. Kimble, the deputy took on that job to go to that scene and investigate that, and he should have done more than just look at it and leave. The next person coming up on that road was Mr. Kimble, so it's our position that he was the person that the deputy took on that job to protect in this situation.
Let me ask you, Ms. Deere, prior to the collision, was there any contact at all between the deputy and the appellant?
No, no, sir. The deputy was dispatched.
It seemed to me, in looking at the cases, there has to be some reliance on the part of the injured party to the obligation created, by the deputy. What facts here would constitute some reliance on the part of your client for that deputy to protect him from this collision?
Judge, we're relying on the fact that the deputy assumed the responsibility of that road. This was an emergency. This was not a normal situation. The deputy could have prevented Mr. Kimble from hitting that tree if he'd have just parked a car on the side of the road somewhere with bright blue lights flashing. or put out flares or had someone standing there with a flag or done something to prevent that from happening. Mr. Kimble was the driver of a car on 104 headed toward Dyersburg, Tennessee that night. And he's the person that the deputy should have been protecting. As far as the appellee's argument, we do not believe that the tree was the fault. We believe the duty of the deputy, the lack of the deputy doing his duty is the cause of the action, and it's not a condition of a road being defective or anything of streets or anything like that that would come under section 203. We believe it's under 205 and immunity is removed. And if we go to that section and we go to the public duty doctrine, we believe that the actions of the deputy were intentional and at least reckless to leave a tree on the highway with someone coming toward it. He should have known, he should have thought that there would be someone traveling on that highway. And yes, that's not the general public. The general public was not on the highway that night. Ryan Kimble was on the highway that night. And in assuming the responsibility, we believe he failed that duty to Mr. Kimble.
I'm assuming that the court granted a motion to dismiss and that no discovery was undertaken in this case. Is that correct?
That's correct, Your Honor.
Okay. So basically, I'm sorry, go ahead.
We had hoped that we could get some discovery before that, but didn't happen.
So the trial court basically looked at the complaint and looked at Mr. Pentecost motion to dismiss and granted the motion. Is that correct?
That's correct, Your Honor. And it's interesting that in the judge's memorandum of opinion, as far as section 205 goes, he made two statements about it. One being that we raised it, and number two, that he didn't dismiss based upon that. Otherwise, he didn't speak to the fact that I believe it was 205. That he didn't speak to any findings of immunity or not on that section of the law. So I'm kind of baffled as to, you know, where do we go with that on that section?
I mean, realistically, Ms. Dyer, what did you expect to uncover if you were allowed discovery that you didn't already know and didn't allege in your complaint?
Your Honor, there are all sorts of agreements that counties and cities and states are allowed to make regarding emergency situations and things like that. And in fact, there are some that we were not able to get as far as the county agreements with the state and the city.
All right, thank you, Ms. Dyer. We'll hear from you again on rebuttal. Mr. Pentecost.
Thank you, Your Honors. May it please the court. James Pentecost of the Madison County Bar, representing defendant Dyer County as it relates to the complaint filed by Mr. Kimble. The complaint was filed on April the 3rd of 2019 concerning an incident that occurred on April the 13th of 2018. As you know, the facts are taken as true, and they are taken as true in this de novo hearing before the court. And those facts that are alleged in the complaint that are true were that there was weather conditions occurring in Dyer County on April the 3rd of 2018. That a deputy employed by Dyer County responded to a downed tree that was existing upon Highway 104, which is a state highway. That said deputy left that emergency and went to another emergency concerning a downed tree upon another roadway. That this tree was blocking the highway on 104, and that the plaintiff did not observe the tree and ran into the tree, causing the complaint that occurred. The plaintiff alleged causes of action, but yet never referenced the Tennessee Governmental Tort Liability Act in her complaint. So when we looked at the case, we looked at it pursuant to the Tennessee Governmental Tort Liability Act because it's alleged against a governmental entity concerning governmental employees. These governmental employees were acting in the course and scope of their employment as alleged in the complaint. There were only two possible theories that we saw that the plaintiff could bring under the Tennessee Governmental Tort Liability Act under 203 and 205. I think that 203 has basically been accepted by the plaintiff in their reply brief. She said they're not arguing that, but the trial court was correct to say that immunity was not waived under 203 because it clearly says that if it is a defective roadway or a dangerous condition that exists upon the roadway, then 203 requires the second step, and that is that said roadway, sidewalk, whatever, be controlled and owned by the governmental entity. And so it's been stipulated, I guess, I'm not going to address that except to say immunity was not waived. Trial court was correct. You then go to that 29-2205, which concerns the negligent actions of employees for the governmental entity. And in our motion to dismiss, we did not believe that 205 applied to this section or to this accident or to the complaint. And therefore, we did not believe that immunity was waived because there was no negligence as to premise liability. In other words, no negligence of our employee caused a tree to fall. Even if it did, it wasn't on our property. There was no duty of an officer that exists in the county as it relates to a state highway. We also allege that clearly in this emergency situation that the duties of officers are not to any particular person, but to the general public. The plaintiff cited several theories of duties, and we argued that to Judge Moore, but Judge Moore did not believe.
Let me stop you and ask you a question, Mr. Pentecost, if you don't mind, please, sir. You say the plaintiff cited several theories of negligence. Was this in a responsive pleading? Was this in the complaint? Or I've reviewed the complaint. That's as far as I've reviewed the memorandum of opinion that's been filed, and I'm trying to figure out how you get from the complaint to the memorandum of opinion. Can that be done here?
I clearly believe it can, Your Honor. Okay. When I said several theories of negligence, no, Your Honor, she alleged several theories of a duty. And that's what we were discussing with Judge Moore at the trial court was the duty under 205.
Were there additional pleadings filed?
Excuse me, Your Honor.
I'm sorry. Were there additional pleadings filed?
No further pleadings were filed, Your Honor.
So you've got the complaint, you've got the motion to dismiss, and the trial court rules.
Yes, sir.
Okay.
And
go ahead.
He was correct in his ruling as it relates to the dismissal, Your Honor. But under 205, the trial court said, I find right now, I'm not going to grant your motion to dismiss as a 205. But the inquiry did not stop there because we went on and argued that even if immunity is waived under 205, you still had the public duty doctrine, which was an absolute defense to any waiver of immunity because the duty was owed solely to the public. To the extent that the court found there was any duty that could be alleged under the complaint, that duty clearly was related to the public. And that's why the trial court, Your Honor, went to the public duty doctrine and addressed that based simply upon the complaint that was filed. Because in Ezell versus Cockrell, the Supreme Court, which that's the infamous case that sets out the exceptions that Judge Clement was referring to and things like that. And that is that it's to safeguard the public employees from suits for injuries that caused by public employees' breach of a duty owed to the public at large. And what we were saying was that even if you argue any breach, first of all, there was no duty, but if that duty was only to the public at large, and that is clearly shown in the complaint, because in the complaint, she says what the deputy did was somehow a breach of a duty to all those traveling upon the road, or all those that were using the road, and that would be the public. That would not be solely her client, that would be the general public. And then under Brown versus Hamilton County, you have this court saying that a duty owed to everyone is a duty owed to no one. And that's exactly what we have here. We have the public duty. And while that is an ultimate defense, the courts have gone on to say that there are exceptions to that. And one exception is when a public officer affirmatively undertakes to protect the plaintiff and the plaintiff relies on it. Well, there was nothing affirmatively done for Mr. Kimble by this officer, nor was there anything that Mr. Kimble affirmatively relied upon. First of all, the affirmative action of the deputy was to go to another emergency with a tree down. And then in the Wells decision, I think it was pointed out, and it's a very basic point, and that is Ms. Dyer is alleging that there's a failure to warn or a failure of the deputy not to act. And so therefore, how could you have an affirmative reliance by Mr. Kimble? So the first exception is gone. The second exception relies upon a statute, and if a statute gives a cause of action, if a statute gives a cause of action to a class of people, and that a statute gives, and that the plaintiff is in that class of people. And that, again, that exception does not apply to these facts. There is no statute. Again, the duties as cited by the plaintiff were simply duties to serve and to protect. The third exception is that basically that you allege and show by the facts. You can't just simply say that the action of the officer was reckless. The action of the officer was intentional. Heard versus Madison County, where Judge Farmer exclusively wrote and said, the allegation that Sheriff Woolfolk engaged in reckless conduct, however, is a legal conclusion. In ruling on the defendant's motion to dismiss, the trial court and this court on appeal are not required to accept such legal conclusions as true. The only factual allegations for the plaintiff's claim of reckless conduct is that Sheriff Woolfolk was devoting his time and attention to the political aspects of his elected position rather than fulfilling the duties statutorily imposed upon him by the statute that applies to the general public. So for Ms. Dyer to simply say that there's intentional or reckless conduct does not cause the trial court to just immediately say the public duty doctrine doesn't apply because she's used those specific words.
Well, let me pose a question to you there, though.
Yes,
Ms.
sir.
Dyer and you both agree that this case was disposed of on the pleadings. And if I'm taking your interpretation of Judge Farmer's Madison County case correctly, you're saying there's got to be more than mere allegations. In this case, there was no discovery that was conducted to ascertain if that conduct that she's alleging rose to the level of recklessness. So isn't that problematic with that argument?
No, Your Honor, I don't feel like it's problematic because, again, the allegations in the complaint don't show reckless conduct.
Well, I mean, she
and
alleged,
that's what's required.
Okay.
Excuse me.
Hold on
go
a
right
second.
ahead.
Did she not allege, or could it not be inferred from what she alleged, reckless conduct in that the deputy realized there was a tree on the road, The deputy got another call. The deputy didn't do anything to illuminate the tree on the road, whether it be have someone else there, put out flares, do anything. He left that situation and went to another situation because he was called to another situation, but he didn't do anything to notify the public at large that this was a potential dangerous situation. So
Well, Your Honor,
why can't you look at that as an allegation of reckless conduct?
Because that is a simple negligent action and not a reckless action, as set forth in Heard versus Forrest. First of all, they even said the deputy being there was and seeing the conduct was not reckless. In Gardner, they talked about the fact that there is a reasonable standard of care, and even if they breach that reasonable standard of care, which we're not admitting, Your Honor, but that's
Sure,
in the
we're at
complaint.
the pleading stage right now.
Yes, sir. And if you take her pleadings, it does not show reckless conduct. It does not show intentional conduct as defined by the statute. In fact, the courts have said that these the third exception does not simply turn on whether the defendant might have had a reason to know that someone was in danger under the circumstances. That does not prove reckless conduct. It may be negligent, but to give it in Your Honor, that is legal conclusions that this court does not have to accept. So there's no need to have further discovery because the action that the plaintiff is alleging in the complaint does not reach that level of recklessness or intentional. So therefore, the court could make that determination and say, no, Ms. Dyer, I'm not going to rely upon you simply using the terms. Show me the facts. Well, the facts are he went to another emergency and he did not warn. Now, is that a breach of a duty? I don't know, but it is not reckless conduct. And the public duty doctrine would allow that waiver of immunity under 205 to not be assessed against the county because it is a duty owed solely to the public. And so I hope I've answered that question in that, yes, we're in the pleading stage, but that doesn't mean that the court still can't grant the motion to dismiss, such as they did in Heard versus Woolfolk, Gardner versus Insurus, I think was the name of the case. Those cases clearly show that. That is the only conduct that the plaintiff alleges as it relates to this specific deputy. All other duties as alleged in the complaint are general public and owed to the general public, but that was owed to the general public too, Your Honor. That wasn't owed. There was no special relationship between he and Mr. Kendall. So even though I disagree with Judge Moore that 205 shouldn't have waived liability, he said it did. That's fine, but he still applied the public duty doctrine, which was allowed as to the pleading. Your Honors, based upon those arguments, based upon what we've shown, then the court should affirm the action and the de novo ruling of the trial court and grant dismissal to Dyer County under the Tennessee Governmental Tort Liability Act and the public duty doctrine. Thank you.
Thank you, Mr. Pentecost. Ms. Dyer, your rebuttal.
Thank you, Your Honor. First of all, I don't believe we've accepted anything under Section 203. Mr. Pentecost sort of alluded to that at the beginning. We don't accept anything as far as their argument at this point in time. As far as the statute controlled and owned by the state, I've read cases that said controlled or owned, and I've read cases that said controlled and owned. And there's sort of an ambiguity there as far as I'm concerned. Is what do you rely on, controlled and or controlled owned? Anyway, we disagree that immunity was not waived there. We don't even think that the highway situation is what we're here for. We're not suing that tree on the road. We're not suing that landowner that owned that tree. we're not out suing for a defective condition. We're suing the deputy for taking on the responsibility. And I don't know how much more reckless you can get than leaving a tree over the road in a storm with somebody coming down the highway. And as far as the public at large and versus Mr. Kimble, we believe Mr. Kimble and the deputy had a special relationship when that deputy assumed the duty to go to that scene and investigate that and control that road, and then to, for whatever reason, go to another tree. We want to know why couldn't the deputy deal with one tree at a time and deal with one and then go to another? He was sent to that particular situation. And as if we'd had discovery, the facts could have shown maybe that deputy might have had a chainsaw in the back of his car, in the trunk. We don't know those things because we weren't allowed discovery, but we believe that the county owed a duty under that deputy's job to, when answering that call, he should have stayed with his job that he had. And we believe he had a special relationship with Mr. Kimble because he showed up in an emergency situation. This is not just a general daily routine. This was an emergency situation. And there were probably several trees down, but when you go to one scene, you can't just pick and choose if you're going to be a public servant. And if you're going to protect, you're going to protect who is coming along in your in the duty that you have in front of you. So we feel like the deputy was reckless. We feel like he owed Mr. Ryan Kimble a duty. We would like to have this thing sent back down for further. Thank you.
Thank you, Ms. Deere and Mr. Pentecost, for your arguments. We will take this matter under advisement. Mr. Hibb.
This honorable court is now in recess until 10 a.m.
Thank you.
Thank you.